Your Honors. My name is Richard Fox. I will be briefing the remaining issues in this case. I'd like to begin by addressing the question presented by the Madam Chief Justice of isn't it permissible or how isn't it a cop-out to say that Congress can't just remove funding? And in the retroactive sense, Your Honor is quite right. That would be relatively ineffectual. But in this case, as my colleague Mr. Allen noted, we're talking about actions that are to take place in the future. It is Sherlock's complaint in this case that the President's actions are affecting its ability to operate a company now and its ability to operate into the future. And if Congress did not want the President's actions to continue into the future, then it could remove funding for any future actions.
Well, what disturbed me, and since you chose to take out the baton, is I question whether we've explored all of Congress's constitutional powers. Because we seem to hang our hat on appropriations without exploring the other options in this. So why don't you entertain me by telling me what you think Congress's authorities are in this situation and then apply them to the facts for me?
Absolutely, Your Honor. Certainly, as discussed, removing funding is within Congress's authority. And Congress has the authority to declare war, under the Declare Wars clause of the Constitution. But the language of that constitutional provision, in the President's view, should constrain the scope of the power conferred to Congress under that constitutional provision. That is, Congress has the power to declare war, as that term was understood by the framers, and as that term is generally understood today. And the President's actions are simply not a war. We are not engaged in a war as a result of the cyber operations that are taking place in the present.
Well, didn't the Defense Authorization Act say attempt to address that issue by adding cyber to what is traditional warfare?
Your Honor is referring to Section 954 of this latest appropriations bill?
Yes.
Your Honor, specifically the language is that the Department of Defense, at the direction of the President, may conduct offensive operations in cyberspace subject to the War Powers Resolution. It's the President's position that that language means subject to the entirety of the War Powers Resolution. The language doesn't say offensive operations in cyberspace are subject to...
Well, it doesn't do that. Does it? Do you think it adds, or is it an attempt to clarify traditional warfare doctrine?
It is an attempt to clarify. It is simply an attempt to remove the argument that no cyber operation can be subject to the War Powers Resolution. There are admittedly cyber operations.
What makes this unique that is not covered by the War Powers Resolution? This particular cyber attack, or cyber attacks, plural.
Your Honor, it's distinguishable in many respects from the type of operation that my colleague alluded to, and an all-out shutdown of a foreign government's .gov domain would certainly rise to the level of a hostility within the cyber.
Why certainly, though?
Well, Congress.
It's not obvious, so why?
Well, with the passage of Section 954, Congress contemplated that there are cyber operations that would constitute hostilities, and so.
But there's a lot of room in that. I mean, cyber operations have there's a lot of wiggle room in there, if I understand it. So where do we draw, is there a bright line?
No, and the President would encourage the court not to draw bright lines in the.
Well, that gives him a little more leeway then, doesn't it?
Well, the Supreme Court has consistently held that the President is due quite a bit of leeway in the foreign policy and war context.
What about so foreign policy, fine, but what if there was a domestic? What if the same thing was happening with domestic servers?
In that case, Your Honor, Youngstown would undoubtedly apply, and the President would likely be acting in an unconstitutional manner. That was the court's primary concern in Youngstown, was the domestic nature of President Truman's actions. In each of the concurrences authored in that case, they were particularly troubled that the President had seized property domestically. But they went on to note that had the President been operating abroad under his authority in the Commander-in-Chief Clause, it would be likely a different outcome.
Who owns the servers in Qatar?
A subsidiary of Sherlock.
Where's that company headquartered?
Sherlock is headquartered within the United States.
So is it technically a U.S. held company? Is it U.S. property? Is what I'm getting at?
It is the property of a U.S. corporation.
But it is in foreign.
Correct.
But you see what I'm getting at,
I
right?
do.
That where are we drawing the line between, if you have is it physically that it's in a foreign country, or is it that it's held foreignly? There's a lot of, if Truman was acting with domestically owned foreign
likely would have been a different outcome in that case, Your Honor, because although it is a United States asset, it is located abroad, and the fact that a United States corporation might own a particular piece of property that is affected in an ongoing military operation should not be the sole grounds for holding that the President has gone beyond his constitutionally allocated powers. I would add on that point, Your Honor, that if the concern additionally were that the President was seizing or taking private property, then potentially a takings claim might be the appropriate action under which Sherlock might bring its case.
They were destroyed. The attacks are clear that there's a lot of destruction of property. Their entire server operations taken down in the foreign land. Again, how do we set, if there's no bright lines, what criteria would you have a court use to try to sort out whether this was an exercise of power within the province Congress, or at least the Congress needs to be collaborating with the council, or is this something the President can make a unilateral decision?
I completely understand the court's concern there. If the court does reach the merits of this case, there do need to be standards by which the court holds the President accountable. I would suggest the following. We discussed the temporal aspect, how long the operation is going on for. That would be one of several factors. The deployment of troops would be a factor considered, in what numbers those troops were deployed, and if they had come under hostile fire.
If we're getting into an era of drone strikes, if we're getting into an era of lessening boots on the ground, and I think rightly so, are the numbers of people involved really going to become that determinative?
Your Honor,
Or
that
continue to be determinative?
it should continue to be determinative amongst a number of other factors. The destruction of property, it is an appropriately considered factor. The use of a kinetic capability is an appropriately considered factor. Are things blowing up with missile attacks? That would be an appropriately considered factor. The nature of the attack itself, are millions of ones and zeros being deployed, or are Hellfire missiles being deployed?
But in this digital age, aren't the millions of ones and zeros just as potentially destructive as a Hellfire missile? Maybe not to life and limb, but certainly to finances and information and IP and infrastructure.
Absolutely, Your Honor, but those are considerations that are outside the scope of war. When we're talking about war and congressional power under the under the Declare War Clause, we are talking about the destruction of property, the loss of life and limb. The physical impacts that take place are those that are confined to the war realm. In the realm of international economics or international commerce, there are a different set of international...
So you're saying that even physical kinetic wars haven't affected international commerce?
Well, they certainly can, Your Honor. But with respect to the applicability and constitutionality of the War Powers Resolution, the President would suggest the court to focus more on war-related factors, as that's...
But where are you defining it? Tell me where you're getting these war-related factors from. What case or what?
Your Honor, the President is not particularly aware of any Supreme Court precedent that has laid out substantive factors for determining when a...
Okay, so when you're saying these physical factors of boots on the ground and life and limb and not international economic, the President is making that up out of whole cloth? Or is he basing that on something? Because if we're talking about the Constitution, and as we go through our democracy growing, it certainly has expanded to include things that the framers never envisioned, and that could include cyberspace, correct? So if that's the case, if he's talking just about kinetic damage to life and limb, isn't it possible that we could include cyberspace and cyber warfare in war?
It is potential. It is possible, Your Honor, and the President concedes that that is entirely possible. The actual conflict between the states of Russia and Georgia are a prime example of when a cyber operation does fall within the context of war.
And you're distinguishing that because there was more damage to... There was more damage?
There was... the cyber operations took place within the context of a shooting war in which there was physical damage, the deployment of troops, the traditional indicia of warfare.
So Salvo of a war?
Uh,
To be considered part of that war?
in a scale that was significant enough, potentially,
But
Your Honor.
what's that scale?
Well, that would be another factor that should be considered by the court. If there were no physical,
These factors that have no basis in art.
I would, that's correct, Your Honor, and I would add that the reason the president is seemingly making this up out of new cloth is because these cases have largely been dismissed on the political question doctrine. The Supreme Court has rarely had occasion to consider these factors.
So is your
Because-
argument that because it's difficult, we shouldn't decide it?
Absolutely not, Your Honor. This court is fully capable of deciding questions.
Take this just another step. You cited these cases, so I don't think this is not out of the blue. But there have been cases in the immigration field, Hofsky and Cheda, where the courts have essentially fielded political question arguments, but have decided, hey, courts can decide the laws. All we're doing is deciding authority of Congress to pass immigration law versus the president's interpretation. Can we take those principles, Justice Roberts' language in Hofsky, and apply them to a foreign case like this? I know you're making a jump, but is that a kind of precedent that we should be looking at, trying to determine whether this is the kind of case that should proceed with merits?
I would have two responses to Your Honor. The first is the president readily concedes that because there is a political aspect to a particular argument or to a particular case that does not automatically make it non-justiciable. Alcantara argues that the Affordable Care Act was a non-justiciable political question, although it was quite politically charged. But more directly to the point of Your Honor's question of, as Your Honor noted, the immigration realm in Chada and the acknowledging a foreign state in Hofsky.
I think it's hard to pronounce.
Yes, it is, Your Honor. Those are quite distinguishable from the war realm, and I don't mean to take the easy way out, but I do have to note that those are certain areas where the president might be afforded somewhat less deference, but in the area as fluid and dynamic and ever-changing as war, the judiciary is ill-equipped to handle this.
But you see, it's kind of circular. We heard the judicial argument, decision-ability arguments before, and now we're trying to determine how do we determine whether this is the kind of action that's consistent with your part of that. The same kinds of criteria that go in to determine whether there was consistency also have effect, and again, must be considered. You're looking at justiciability. They're kind of circular. They're very interconnected. Same kinds of considerations go into that. So how do we determine as a court whether the president's actions are consistent without avoiding constitutionality for now with the congressional intent?
Your Honor,
Or get intent, bare language of the statutory provisions of 1544.
when that statutory provision invades on the clear prerogative of the executive. For example, if Congress were to pass a law that said something to the effect of that Congress has the authority to receive ambassadors, there's no question on that matter. It would simply be within the realm of the president, and the court need not hear the merits of that case. And so when this goes to the textually committed argument, but when something is within the executive's power, is our position that the merits of the case need not be heard to the court. But as we are on the merits of the case at this point, I'll just briefly conclude that war should be interpreted as the framers of the Constitution understood that term. And although war has evolved since the time of the founding, the essence of war does not change over time. And to change the meaning of the Constitution over time, the president would urge this court not to do. As I can see that my time has almost expired, I would conclude by asking this court not to award the extraordinary relief. May I briefly, like I say, my time briefly conclude the extraordinary relief sought by Sherlock in this case of enjoining the president from conducting an ongoing military operation. I thank the court for its time.